Concurrent conflicts of interest. There are, broadly, two types of conflicts of interest: concurrent conflicts and successive conflicts. This unit will deal only with concurrent conflicts addressed in Rule 1.7. The next unit will tackle successive conflicts. Concurrent conflicts of interest exist when the lawyer has one client with interests directly adverse to the interest of another client. For example, the opposing parties in a lawsuit have a direct concurrent conflicts of interest. Obviously, it is not permitted for the lawyer to represent both parties who are suing one another. Rule 1.7 expressly prohibits the attorney from representing opposing sides in a litigated matter. However, the prohibition is broader than that. A concurrent conflict of interest with one client being directly adverse to another client can exist if the two clients have two separate matters that have nothing to do with one another. For example, if the lawyer is representing an employee in an employment matter against Corporation A, it would create a concurrent conflict of interest for Corporation A to retain that lawyer to acquire a subsidiary. A concurrent conflict of interest exists if the attorney is both representing and suing the client, even if the two cases have nothing to do with one another. Directly adverse conflicts are not limited to litigation, however. Directly adverse conflicts can also arise in transactional matters. As Comment 7 notes, it is a concurrent conflict for an attorney to represent the seller of a business in negotiations if the attorney also represents the intended buyer in an entirely different matter. Actual or potential conflicts of interest. Among concurrent conflicts of interest, there are also actual conflicts and potential conflicts. An actual conflict includes the examples we have just reviewed, where one client's interests are directly adverse to another client's interest, or where the lawyer's interests are directly adverse to the client's interests. There are also potential conflicts in which the lawyer can foresee that two clients' interests might diverge, or the lawyer's own interests and the client's interests might come into conflict. The language of Rule 1.7a2 defining this sort of concurrent conflict is as follows, quote, "There is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person, or by a personal interest of the lawyer," close quote. Comment 8 provides illustrations of where a lawyer's responsibilities to one client might be materially limited by the lawyer's responsibilities to a second client. For example, if an attorney represents different individuals forming a partnership, she might not raise all the ideas that would convenience partner X because of her loyalty to partner Y or partner Z. When might a lawyer's personal interest materially limit his work for a client? There are examples set forth in comments 10 through 12. For example, if the lawyer is accused of being a party to the client's fraud, it may be impossible for the lawyer to continue representing the client. If the lawyer is seeking employment in a firm representing the opposing party, this could significantly limit the lawyer's representation of the client. Comment 9 notes that the lawyer's duties of loyalty and independence might be materially limited by the lawyer's responsibilities to former clients or to third parties, for example, as a fiduciary. Waiving conflicts of interest. In some circumstances, Rule 1.7b permits the lawyer to represent clients who have concurrent actual conflicts of interest if the clients waive the conflict and if it is reasonable for them to do so. Similarly, the client might waive the concurrent potential conflict that could develop with the attorney. The four criteria for the client waiving a concurrent conflict of interest are that 1. The lawyer reasonably believes that she will be able to provide competent and diligent representation to each client affected. 2. The representation is not prohibited by law. 3. The representation does not involve asserting a claim by one client against the other in the same litigation. And 4. Each client gives informed consent confirmed in writing. Rule 1.7 permits an attorney to handle a case if the interests of another client or the lawyer's own interests are or may become adverse to the interests of the client in the new case if all involved clients are fully informed of the conflict and provide informed consent confirmed in writing, waiving any conflict, and if such a waiver is reasonable. In some instances, it is simply not reasonable for the client to waive the conflict of interest, and the lawyer should not ask him to do so. For example, if two criminal co-defendants want to defend themselves by pointing the finger at the other one, this is an untenable situation, and one lawyer cannot undertake both representations. Comments 14 through 17 discuss non-consentable conflicts of interest. If the conflict is one that reasonable clients might waive, the lawyer must ensure that both clients are fully informed about the conflict, including any problems that might arise as the case goes forward. For example, if both co-defendants initially claim to have an alibi and a complete defense to any involvement in the crime, it might seem that representation could be undertaken. But if, as the case develops, it is clear that both co-defendants were at the scene of the crime, one might wish to plead guilty and testify against the other, one might claim he was less culpable and the other was the ringleader. Once these developments occur, the lawyer will typically be unable to continue representing both clients. In fact, at that point, the lawyer would be obligated to withdraw from both clients' cases. We will explore that need to withdraw in our next unit on successive conflicts. But at this point, it is simply necessary to understand that a potential conflict that can be waived might develop into an actual conflict that cannot be waived. So, it is very important at the outset of such representation with potential conflicts that the lawyer explain all the possible developments that could occur and the possible need for the lawyer to withdraw entirely from the case if a potential conflict develops into an actual conflict of interest. Comments 18 through 19 address obtaining informed consent to such conflicts. Attorney equals firm. With respect to concurrent conflicts of interest, the rules that apply to an attorney also apply to the attorney's firm in accordance with Rule 1.10. For example, if one lawyer in the firm represents the company suing Corporation A for employment discrimination, can a different lawyer in the firm represent Corporation A to acquire a target company as a subsidiary? The answer is still no. Even though the two lawyers may have nothing to do with one another, Rule 1.7 deems this a concurrent actual conflict of interest, and Rule 1.10 treats the law firm exactly as it treats the individual attorney.